This is the weekly Health Law News Nugget from Southern Health Lawyers. I'm Rich Sanders.
And this is the Health Law News Nugget for April 16th, 2019. Well, I hope everybody had a great tax day out there in News Nugget land and made it through in one piece to fund our federal government for yet another year. This week's News Nugget talks about the actions of the federal government and specifically how the judicial system is going to reinterpret the Patient Protection and Affordable Care Act that Congress passed in 2010 and that President Obama signed into law that spring. So, as many of you know, especially of those of you who've seen me speak about this topic in person over the years, the Supreme Court decided in 2012 that the PPACA was constitutional. The main reason that the majority opinion authored by Chief Justice John Roberts determined that the PPACA was constitutional is that Congress under the Constitution has the power to levy and collect taxes, and the individual mandate, otherwise known as the personal responsibility fee, that Americans have to pay if they don't have health insurance in a given year, the Supreme Court determined was a tax and fell under Congress's powers under the Constitution. Well, fast forward 5 years, and the Trump administration at the end of 2017 and Congress got together and said, okay, well, we're not able to repeal and replace the PPACA. There was a bunch of news about that in 2017. But what we will do as our version of healthcare reform is instruct the IRS not to collect the penalty fee or the individual mandate. In other words, the teeth are now out of the dog. So, as a result, another round of lawsuits began based on a very basic theory that if the tax provision of the PPACA was the key to its constitutionality under the Supreme Court opinion from 2012, without the tax power now in 2018, the law is no longer constitutional. A federal judge in Texas has already ruled that that's the case, specifically because the Supreme Court opinion from 2012 says, without the tax, this law must fall. So now it's headed to the Fifth Circuit Court of Appeals, which is the Court of Appeals that hears cases from federal courts in Texas, Louisiana, and Mississippi. The news from last week, according to Modern Healthcare, is that this case is going to be heard by the Fifth Circuit sometime this summer. I think it's scheduled for the first week of July. What that means is that the Fifth Circuit, either way, whether it upholds the trial court's judge's decision or turns it over, that should make it to the Supreme Court by next spring, which means that by next July, June or July, we may have an opinion on the Supreme Court or from the Supreme Court on this new tax-less Patient Protection and Affordable Care Act, which means that once again, just like 2012, we'll have a presidential election where a Supreme Court decision on healthcare could factor significantly. We'll always keep you posted on developments from Washington here on the News Nugget. I'm Rich Sanders, and thanks a lot for watching.